Tom, we probably have a few listeners who were in the middle of an eviction before COVID hit. What is their game plan? So they filed in January. They were going through the process. Tenant said, "Ooh, this is a freebie. I'm safe." Is it the same that you laid out earlier in the episode, or is there any difference because they had already got it in motion?
The argument as it stands today, we'll again call it mid-December, is if, and this is always fluid, right? What I say today might be different in January, might be different again in February and March and April and beyond. But, so let's just keep this to present times, which is December of 2020. But ultimately, if cases are pending in pre-COVID, the expectation is that those cases will be heard. Let's say the case was filed but not yet heard, or a case was filed that was heard and you got the eviction order. So let's start with that one first. If you got the eviction order and it's with the sheriff, the sheriff doesn't have permission under current, Illinois law to be evicted for non-payment. Now, if you find that they're dangerous and hazardous to the property, imminent threat to others, call it, violence, drugs and beyond, you have the option to go into court and say, "Judge, this is a serious, situation that's impacting the rest of my residents. We need to proceed on this one." And we've done this, and several attorneys in this arena have done that successfully. So that's a good route if you have it. But those are only at the highest level of emergency that they're actually going to follow through on and finish out the eviction. So everything else, call it 95% of the cases are just kind of stuck in limbo. Sheriffs will not evict. At the same time, judges are waiting to hear these old cases from January, February, March to actually have a hearing on them or a trial to see what's going to happen there. If you end up getting an eviction order, you're entitled to your judgment. But even if you place with the sheriff still can't execute on that order. Does that make sense?
Yeah.
Yeah.
So based on that, I heard, Tom, we just have to have Mr. Rowley back January, February, March to make sure we're always current on our information.
Look, man, it's going to be tough. It's tough out there. It's it's confusing. There's a lot of information back and forth, and we're on a good attorney email with a dozen of us trying to understand everybody's opinions, thoughts, and questions. And it's good to know that we're all wondering the same things and all kind of a little confused. But we'll get you through it. I promise you.
One other question before we roll on to kind of the prevention of all these things when it comes to screening up front. But Cook County, if you're listening to this and you're in Cook County, not Chicago, is it all the same? Just you don't have to hand out the 14-day or the right to know?
The COVID, yeah. So let's say non-Chicago cases, every tenant will receive two documents: the declaration, which we talked about earlier in the call, and the termination notice. We could go into another layer at the federal level. I think it's just too much at this point. But there's the CARES Act and the federal level. There are some rules around that, basically saying if your property is a covered property under the CARES Act, you got to add some different layers to that. And I would just tell your listeners to talk to your attorneys on that component and go from there. But I think we've hit really the basics on today on evictions and how to properly prepare and serve. And that's enough ammo for some of these operators and listeners to use.